have an extra test for Cody?
Servitude?
Yeah, servitude.
Chapter 9.
They were all
All right, so the test for Chapter 9, it's 10 questions. The first question is, under Louisiana law, there are two types of servitudes. Is it A, movable and immovable, B, consumable and non-consumable, C, personal or impredial, D, contractual and statutory, or E, none of the above?
C.
An example of a predial servitude is A, where children own a naked interest in a house after a parent passes away, B, a private road that is used to access multiply separately owned homes, C, when your parents give you permission to use the car, D, the driveway from a public road to your garage door, E, all the above, F, none of the above.
B.
I didn't hear that resounding B like I heard
Which
you
one
C.
is
Is it B?
B.
It's B.
It's
good.
B.
It's B.
Okay.
Which of the following are true about usufruct and naked owners? 1, the duration is for the life of the naked owner. B, does not attach to the insurance proceeds if the premium of the policy is paid by the naked owner. C, the usufruct of a movable is a corporeal movable. D, the naked owner can sell or donate the naked ownership to another naked owner. E, all of the above. F, none of the above.
B.
Which of the following are true about usufruct and naked owners? Is it the duration is life of the naked owner? Who's it for the duration is the life of? Usufruct. Does not attach to the insurance proceeds if the premium of the policy is paid by the naked owner.
That's what I thought it was.
That's what I thought it was.
That's what it is?
Is that it?
I'm just trying to figure out why isn't C correct too? The usufruct of a movable is a corporeal. Oh, because it's a non-corporeal. It's incorporeal.
Okay.
All right. The D, the naked owner can only sell or donate to no condition. All right, you're right. The answer is B.
Why he can't sell to another naked owner?
Only. The question says, the answer says only. You can sell
He can sell to anybody?
to anybody. Absolutely.
Ah, okay.
So it's B. Which of the following items does the usufruct own as an operation of law? The furniture, the groceries, the office supplies, all of the above, none of the above.
E.
Which of the following items does the usufruct own as an operation of law? So you remember the usufruct owns as an operation of law the consumables? Is this the one that
This
furniture?
is the one that's a little tricky because I don't know, is a car a consumable? I know furniture is, groceries is, office supplies is.
Where do you have car?
I have car.
My answer doesn't have car.
Mine does.
Mine does.
It's a
You got
car.
a different test than me.
I have a different test than you guys do. So mine doesn't say
So
car.
if you
I have-
eliminate car,
See,
it's all
mine
of the
does.
above.
if you eliminate car, it's all the above.
Okay,
Alright.
so I'm
Every,
scratching.
what happens is, what's important for you to realize is it's the consumables.
Yeah.
Whatever the usufruct is over that's of a consumable nature, the usufruct owns as an operation of law. Okay, it's the non-consumables that they have to preserve and maintain and only use the fruits of.
So scratch out car and write all of the above.
The following example are civil fruits: rents from investment property. B, the interest paid on a savings account. C, a rebate check from your cable company. D, crops. E, wool. F, A, and B. G, A, B, and C. H, C, D, and E. I, D, and E.
Can I buy a vowel?
Yeah. Which vowel?
I think it's G.
You think it's G, A, B, and C?
No?
I thought it was I. D&E.
I thought it was H.
It's F.
Civil fruit.
Civil fruits. This is the reason why D and E don't work. Civil crops and wool are natural
Right.
fruits.
So it's not those two.
And a check from your
So
cable
why wouldn't
company
it-
doesn't
rents?
apply. I
Is this
don't know where
a-
that's at, but it
And a rebate, we determine a rebate is not a fruit. A rebate, there's actually a special definition in the chapter of what a rebate is.
Rebate.
And a rebate's not a fruit. So the answer is A and B. It's the rents from investment property, it's the interest paid on a savings account. Those are the civil fruits.
So it's
If the
F.
question had been, which of the following are examples of natural fruits, crops and wool would have fallen into that category. All right?
So silver fruit or what now?
It's
Well,
money.
rents,
Money?
interest paid on a savings account.
Money.
Yeah.
Okay.
Well, I don't know that you can only say money,
No,
but
it's not, but that's primarily.
but that's primarily what it is.
Except the rebate.
The rebate's not the rebate. There in the chapter.
It actually
It
addresses
specifically addresses why a rebate is not a fruit.
Okay.
You know, typically
because you actually paid it, and they're just giving it back.
it's like a yeah.
It
So what
wasn't
happens is like
earned,
the
it
reason
was-
why
it
it's
was a
rent
default
is
type.
because
Right.
the unit that's being rented is not diminished by the payment of the rent. Every month I get a new rent check, and there's no diminution to the value of the unit that's generating the rents. And then so a rebate is kind of a quasi refund.
It is a refund, so
And that's
it's
the reason
not.
why it doesn't fall into the fruit category. Number 6, a usufruct terminates under the following events: remarriage of a naked owner, death of a juridical usufructuary, 30 years from the date of probate filed by a surviving spouse, D, death of a natural usufructuary, E, A, and B, F, none of the above.
Put A and D.
A and B?
D.
Not B.
A and D. Why is the remarriage of the naked owner, Janet, a triggering mechanism?
They don't have use of it.
Wait,
Yeah, they don't have usufruct.
yeah, because they don't have use of
That's right. So the remarriage of the naked owner is not a triggering event.
Right.
The answer is D, the death of the natural
Just
usufructuary.
D.
Why is it not B? Why is it not death of a juridical usufructuary?
Because that's a business.
That's right, they don't die.
That's corporal.
That's right. And 30 years from the date of probate,
Dissolve,
what's that? But it's the death. And look, I know what I can see what you're saying, and there is a basis for a dissolution of a LLC or a corporation having some timing event, but they don't die. And so what you don't want to do is take something that's given to you like death, rationalize it as being something else that might work, and then trying to answer the question based upon that. Because Dr. Matthews won't cut you any slack on it.
Okay.
And he intentionally uses that word.
And he will intentionally do that to you, that's right. And it's not 30 years from the date of the probate of the filing of a surviving spouse. That was a time frame. The 30 years was a time frame, but it was a time frame related to juridical entities. It had nothing to do with spouses. All right, so that was intentionally
Did
in there.
anyone question that we skipped? Is that?
Can we back up?
Sure.
Where has anyone, what is the
Yeah.
other type of fruit
Sure.
discussed in this chapter?
What is it?
Natural.
Who did natural?
Corporal?
Corporal.
I don't know.
No, natural and civil.
Natural and civil.
Right. Which of the following are characteristics of habitation? Number 7, it is transferable. It is created and extinguished in the same manner as usufructs. It extends only to the death of the person granted the right. Only applies to unharvested crops. None of the above are B and C.
B and
B
C.
and C. F.
Let's go back to habitation and take a look.
What is the answer on the answer sheet?
My answer, you have on the answer sheet B. Is B and C? Habitation on page 103 is the second kind of personal servitude. It is a non-transferable right of a natural person to dwell in the house of the other. It is created and extinguished in the same manner as usufruct. Unlike usufruct, the right of habitation will never arise by operation of law. Like usufruct, it usually extends until the death of the person. I like C too. I like F, B and C.
But what about the word only?
B and C.
Extends only to the
B
death
and C,
of
not
the
D.
person
I know
granted
that,
the
It
but
right.
says
in
it's
C,
only
it
to.
it has that word only. Does that nullify it?
Yeah, because it applies to more than unharvested crops.
Okay.
Which of the following are characteristics of it?
No, what she's saying is
Just
on
talk
number
about- just
C,
saying
they
it's-
also say only.
It extends only to the death of the person granted the right.
Oh, I'm sorry. Oh, that's the reason why, okay.
That's why-
I'm sorry, guys. My answer sheet says B. My answer sheet says B. I'm trying to rationalize why it's C. I'm taking the exact opposite advice I
Okay,
just
so it's
gave.
only B.
And because it is extends only, thank you, Lavette, because it says extends only to the death, right here it says it's typically granted until death. That's the reason why C is not the answer.
Because it says only.
Thank you, Lavette.
You're welcome.
Thank you.
Kudos, girl.
Thank you.
Kudos to you.
According to our text, which one of the following is one of the 3 kinds of predial servitudes? Usufruct, conventional, statutory, corporeal, incorporeal, none of the above. Conventional. That's right. Your neighbor builds a swimming pool in their backyard and it creates a swale that brings water into your yard every time it rains. This is an example of a voluntary servitude, a natural servitude, a legal servitude, or conventional servitude. All of the above, none of the above.
No,
No.
none of the above.
You're right, Lavette. None of the above.
Okay.
None of the above. It's just a nuisance. It's not
Yeah.
a servitude of any kind. It's just a nuisance. A predial servitude can be extinguished by which of the following ways? Marriage of the usufructuary, prescription of non-use, death of the usufructuary, disorientation, none of the above.
Description of
Description.
Prescription of non-use. Very good, Shannon. That's absolutely right.
Is that another word for confusion?
Yeah. So listen, before we get started in the donations, I want to expound on something that Lorraine touched on at our last meeting. And it's not that there won't be a different time to kind of bring this up, but it's kind of fresh on my mind because I've been thinking about it ever since. When I was telling a little story about the couple that got the divorce just so they could get into the husband's 401k and they never remarried and it caused all kinds of problems when they died, Lorraine suggested that they might be common law married. And as a result, that the usufruct would apply. So I just did a closing for a couple, and I'm a closing notary. So what I do is I for the most part, I sit down with people and I go over their financial papers when they're buying and they're refinancing their houses. And I'm doing a closing for a young couple, and younger couple, and they've just moved here from Texas. And when I walk into a closing, I've got a cheat sheet. And the cheat sheet tells me what I need to collect from the clients. It says collect the driver's license, collect the deposit, collect their money, that kind of stuff. My cheat sheet says collect buyer's marriage certificate, which is a first for me. I've never been asked to collect a marriage certificate before, but I said, did you guys bring your marriage certificate? He goes, oh, did we bring a marriage certificate? So he reaches in, he pulls it out, and he hands it to me. And they got married just 5 days before. I said, what's the story? He says, banker made us get married to qualify for the loan.
What lender was that?
I'm not going to say any
Okay.
names.
Okay.
Banker made us get married to qualify for the loan. And I said, I'll tell you what, that seems like a stretch to me.
That's because this is a community property state.
I'm getting to it. You're
Okay.
absolutely, you're on the right track. I said, that seems like a stretch to me. I said, what was the reason for making you get married? He goes, I wish I knew. They didn't give us any explanation. They gave us a choice. Either get married and close today or not get married and close 45 days from today. And I said, wow. I said, I'm sorry. I've never heard that before, but it seems like it's a reach. So we go through the closing, and most of us file our tax returns electronically. Consequently, none of us have signed tax returns anymore. And you know, to qualify for a home loan, the first thing you got to do is give the banker your tax returns. Those tax returns often come back to closing, where they've got to be signed by the client so that the banker has a signed tax return in their file. I get to the tax return portion of the application, and they filed married. And I said, what's going on here? I said, you guys got married 5 days ago. How is it that you filed the last 2 years of tax returns as married? He says, well, we're common law married. We came
They
from
were from
Texas.
Texas.
We've been common law married for 3 years because we lived together for 10. And I said, really? I said, listen, I'm going to take everything back I said about your banker. Not only is it completely understandable why they made you get married, it's also very reasonable why they made you get married. He says, do tell. I said, I'll make an assumption, before I give you the answer to the question, make an assumption that when you filled out your loan application, you checked the box that said you were married. He says, well, of course. And I said, and throughout the entire process, everything that you gave them indicated that you were married. He says, yes. I said, you're not married in Louisiana. We don't recognize common law marriage here. You're just boyfriend-girlfriend in Louisiana. You might be married in Texas, but they don't fly here. And I said, do you realize when you signed your application, you said, under penalty of perjury, every representation that I've made to you in this application is true and correct. He says, yeah, I do think I remember reading that. I said, so the bank gave you a choice. Either get married and ratify all this misinformation you've given them over the last 2 months to qualify for your home loan, or we'll shut it down, we'll start it over, and you can apply for your loan as boyfriend-girlfriend. And he goes, well, I really wish they'd have told me that. That makes a little bit of sense. He said, is this that Napoleonic law I've been hearing about?
Welcome to Louisiana.
And I said, in a manner of speaking, it is that Napoleonic law. We don't recognize common law marriage, so if you come here... Now, here's the thing. A lot of people come here from other states where they may be common law married, and they may never have an issue. May never have an issue with it. May go off through their entire Louisiana lives holding themselves out as husband and wife and never ever run across a problem. But here's a scenario where they could run across a problem. This is their second marriage, and they've got biological children from first marriages. And they come to Louisiana and they buy a house, and the bank doesn't catch it. Let me tell you, the bank caught it because she didn't have his last name. And that's not ridiculously...
There are some married couples who do that.
Absolutely.
Yeah,
It's not ridiculously uncommon, but it's pretty unique. And about a week or so before the closing, someone called and wanted to confirm that she didn't take her husband's last name. And she shared with them that in Texas there wasn't a ceremony of any kind. They're just married by default, and so there was never an opportunity to change her last name. And that's what set the wheels in motion for them to ask, because the bank was close to closing their loan without ever finding this out. Had she had his last name, they probably wouldn't have found this out. But let's just say this is their second marriage, and they come here with biological children from their first marriage. They buy a home, they think that they're in community property, they don't bother getting a will, they end up with a usufruct at the death of one of the spouses, they go to a notary. They go to a notary because maybe the house is worth less than $75,000 and they have no other assets, and they get a small succession done by a notary, or they have a house that's worth more than $75,000 and they go to an attorney and they get a succession done, but they represent that this was their community home, this was their husband and their house, and that they should have a usufruct. And please tell me my horrible stepkids aren't going to be able to kick me out of this house.
They can't tell.
If you don't know that they got married in Texas, you're going to tell them, don't sweat it. They're not going to be able to kick you out. You're going to have a usufruct. and you complete the succession, and she's in the home, and all of a sudden she gets sued for partition. The evil stepkids want to kick her out, and they make the allegation. Now, you're not married in Louisiana. The operation of law usufruct that kicks in when dad dies doesn't kick in for you because it was never a community asset. We own half this house, therefore we want you to either pay rent to us or we want you to sell it and give us our half of the money. And that would, unfortunately, be the case because we don't recognize common law marriage here.
That's why me and my wife got married finally.
Really? You got evil stepkids?
Yep.
Well, here you go.
And I have an evil mom.
So when I got married, I closed on my house May 1 and we got married May 13th.
Tricky. You're a separate property? So at any point in time, you tell him, hit the road, Jack. He's got to go. All right, so we're going to start on page 123 with donations. The very, very top part of donations, it says donations in Louisiana are those that are made during the life of a person and intended to have effect immediately and irrevocably. Those that are made in contemplation of death intended to take effect upon the donor's death. When made during the life of the donor, these donations are called inter vivos donations. Very important. When made during the life, when made in contemplation of death, these donations are called mortis causa. Very important.
So like if they're in hospice, it's mortis. If they're
in hospice, they're still alive. And if they manage to do a donation while they're in hospice, it's still inter vivos. Mortis causa donations are donations that take place typically in the context of a final will and testament. They've died, their final will and testament takes over, and their final will and testament may call for the transfer of property that way. So if there's a breath, if the pen's in their hand, it's inter vivos. Yeah, there's not varying stages of it. These are the only methods by which property may be acquired gratuitously without any payment or cause. All right, so let's skip down to present and immediate transfer inter vivos donations in the bottom of page 123. A donation inter vivos divests the donor of the property presently and immediately upon the donee's acceptance of the donation. In other words, an act purporting to donate property in the future, unless it is a donation mortis causa, is null and void as a donation, though it may be some other kind of contract. So if I say, Sanjanita, I'm going to donate my house to you a year from now, what they're saying is that doesn't work. That's not a valid donation. It can't be some sort of stipulation as to something that's going to happen in the future. But they said you might be able to squeeze that transaction into some other kind of transaction to make it valid. They give you an example here. They say, for example, if Adam executes an act purporting to be a donation inter vivos, providing that if Betty moves into my home and cares for me and my failing health for the next 5 years, I will at the end of that period donate to her my tract of land in Tensas Parish worth $500. That would be an invalid donation inter vivos because it's an object in the future, but it actually might qualify as an onerous donation. It might qualify as other versions of contracts as well. I mean, it might simply be a services contract, but instead of paying someone in cash, you're going to pay them in property. So just because a transaction may fail to meet the elements of a donation doesn't necessarily mean we scratch it. Doesn't necessarily mean there may be a way to back into making that transaction valid.
So even though he used the word donate in the transaction, it doesn't make it null and void. It could be.
You can make an argument. You can make an argument that even though the word donation was used, that the intent of the parties justified this being a services contract or something else. That's right. All right, page 124, irrevocability. An element of the donation inter vivos is that upon acceptance by the donee, the donor relinquishes control or dominion over the property donated and places it within the dominion of the donee irrevocably. If control of or access to the property is maintained by the donor in the act of donation, it is not a valid donation. All right, so one of the reasons I was a little flummoxed with that test is I didn't look at the test before we started tonight because I have spent a good portion of the day trying to figure out what that paragraph means right there. This makes no sense to me whatsoever. And I did the research on it, and I even asked my business partner, and he took a look at it, and he said, that can't be right. So let's read it again just to make sure we understand exactly what it's saying. An element of the donation inter vivos is that upon acceptance by the donee, the donor relinquishes control or dominion over the property donated and places it within the dominion of the donee irrevocably. If control of or access to the property is maintained by the donor in the act of donation, it is not a valid donation. The next sentence, a donation of the naked ownership of property reserving the usufruct of the donor is not a valid donation because the control of the property remains with the donor. If I have a house and I say, Mom, I'm going to donate the naked interest in my house to you, I'm going to maintain the usufruct. I'm going to continue to live there. I'm going to continue to pay the taxes. I'm going to continue to pay the insurances, but you're the naked owner, and I give her that naked ownership. This says that's not a valid transaction.
Because you didn't donate it to her. You put it in her name to get out of doing something.
Well, you know, that's kind of funny you should mention that, because I do believe that may be a part of the reason why this isn't a valid transaction. So I did some research on it, and this is kind of what it boils down to. In 1974, we changed the laws in Louisiana to make the very transaction we're talking about here valid. So from 1974 until 2009, a donation of a naked interest in a piece of property was a valid donation. In 2009, they legislatively revamped the entire section of the code that covered donations, and this particular code article that made the 1974 donation of naked interest valid just was left out, just wasn't included. And so my partner, who's much better at legal research than I am, said he couldn't find that since 2009 up until today's date that we've had a case in Louisiana address this issue. So it's not been tested to see if it was purposely cut out or if it was inadvertently cut out. But I'm willing to bet that if you asked a handful of notaries that weren't necessarily legislatively up to date, who's done any kind of notary work from 1974 to 2009, if this would be a valid transaction or not, they would tell you, yeah, sure. Because it is something that happens pretty often for the reason Lorraine just pointed out. It's the number one way to get rid of your creditors is to take the interest of your assets and give them to someone else. If all I have is the usufruct of my house, they really can't go get my house because it doesn't belong to me. I just get to use it. The naked ownership belongs to someone else. And so there's a distinct possibility, my partner and I actually kind of came to that conclusion today, that this may have been intentionally left out because people were taking advantage of it for creditor avoidance purposes. They were trying to circumvent their creditors being paid by giving their assets naked ownership to people, maintaining the usufruct, when in reality, they haven't done anything. If I still have the usufruct of my home, it's still my home, even though I've taken away an element that now makes my house unattractive to a potential creditor.
Donate it to her and then pay rent, sign a lease.
That may be one of the solutions. So, for the purposes of the test, if the question kind of comes up and the example that you're dealing with involves a donation of a naked interest, you've got to know that that's not a valid transaction, and apparently it has not been a valid transaction in Louisiana for at least the last 7 years.
A donation of a naked
Interest. Not valid. And the reason it's not valid is because the law doesn't feel as though if the usufruct still has complete control over the asset that they donated, that it can't be a valid donation on that basis. All right, so the next paragraph says the sole exception is the usufruct of a parent over the property of his minor child. It says such usufructs according to that revised statute may be reserved if made in the act of donation, otherwise the usufruct shall not attach to the donated property. The parental usufruct of Article 223 has been repealed since January 2016. That's fresh.
Really?
And it's been replaced with the right of administration of the minor's child's property. By replacing the parental usufruct with the right of administration, the new Civil Code Article 229 makes exception to the rule that a usufruct may not be retained by donated property superfluous. And so what they're saying is by right of administration, they're talking about creating more of a trust relationship than a multi-level ownership relationship. Whereas the parent of a minor child who's got property, I've got the right to manage it and administer it on their behalf, but I don't necessarily own an element of it, is what they're talking about. All right, nonetheless, a donor may revoke a donation inter vivos under certain limited circumstances. We're going to see exceptions to revocability in a little bit. The revocability of donations mortis causa. Donations mortis causa made in testaments, on the other hand, take effect only upon the death of the testator and are revocable at any time prior to the death of the testator. All right, y'all see that? Because testaments don't get recorded anywhere until a person passes away. Testaments, for the most part, are the client's private, confidential documents. And so I don't know if I've talked to you guys about this or not, but you know, you're going to find yourself in a situation if you're going to be doing wills for your clients, where your clients will inevitably ask you, "Are you keeping a copy of my will here? Are you keeping an original of my will here?" And there's two schools of thoughts on that. My partners both came from big law firms in the city where it was customary for the attorney to keep not only a copy of the will, but to keep an original version of that will. And they kept it in a big safe. And personally, this was a school of thought that was shared with me, that one of the reasons that you do that is so that they've got to come back to you for the succession work. It's kind of a way of reeling in the repeat business, so to speak.
Yeah.
My partner doesn't feel that way. My partner says no, people lose their copies, they get lost in floods, and we got to have these here because they might also die in those same events. And we got to have a copy here to allow the heirs to probate the will in accordance with their last wishes. I came up in a small law firm. I've always been in the title business, and title companies are typically owned by small law firms, if not single practitioners. And we simply don't have the space to keep this stuff. And so I've always kind of come up where the attorneys that I've worked for said, no, you give the client everything. You don't keep anything. If they come back to you, great, but we don't want to be responsible for having to store and maintain this stuff. We simply just don't have the resources to do it. So whether or not you choose to keep their copies or not is entirely up to you. But the idea is that if there is in fact a copy of it, and a person decides on a whim that they no longer want this will, and they rip it up, they got to now come hunt you down and get your copy and make you do the same. Because one of the things that a client loses when they leave a copy of their will with you is the unilateral revocability that comes with the flexibility of having the only version of the will. Does that make sense? Yeah? Okay. So the revocability of donations morta causa, if you have the will, you can revoke it at any time. But what happens when you die? Now it's irrevocable. Exactly, it's irrevocable. There's nobody there that can take it back at that point in time. It becomes irrevocable upon death. All right, bottom of page 124, generally donations are made purely gratuitously and take effect immediately upon the donee's acceptance, but donations can also carry conditions or charges upon the use of the property or the status of the donee. Donations can also come with a right of return in the event the donor survives the donee or the donee's descendants or both. All right, charges or conditions. The donor may impose on the donee any charges or conditions he pleases prior to the donee's acceptance, provided that the charges or conditions contain nothing contrary to law or good morals. If the donee accepts, he acquires the thing donated subject to those charges. Examples of conditions that have been held in courts in the past include donations of property to be used solely for park or recreational purposes, educational purposes, or with conditions upon the donee's marital status at the time of the acceptance. We've used an example historically where mom's got the house that everybody goes to for the holidays. It's the big house, it's accommodating. And so we would use the example that mom donates the house to me, but only on the condition that I continue to hold all of the family functions there. That's not something that would be contrary to good morals, something that would be upheld. I couldn't have a piece of property and say, Cody, I donate my house to you as long as you continue to operate the illegal alcohol distilling operation, the moonshine operation I got in there. So that's an illegal condition that wouldn't fly. Can't do that. So that's what they're talking about. So you can put a charge or a stipulation on a donation provided that it falls within that category. All right, so the second paragraph in that section says the donation, once accepted, becomes irrevocable and divests the donor of the property in favor of the donee, subject only to those charges imposed prior to his acceptance. The charge or condition cannot divest the donee of the property and deliver it to another person upon either the occurrence or breach of the condition, because that would constitute a prohibited substitution. That's important. Highlight prohibited substitution. We'll talk about that throughout this chapter and probably throughout the book. When I was in law school, prohibited substitution was called hand from the grave. That was the term that we used. It was this concept where you really weren't giving anything to anyone. You were dictating where it went subsequent to their use. So when people come in and sit down with me and they do will consults, and they're like, I want to give this to Sanjanita, and after Sanjanita dies, I want it to go to Cody, and after Cody dies, it goes to Janet. And we tell them that it can't work that way. Once you give it to Sanjanita, that's as far as it goes. Now where it goes is entirely up to her. You can't dictate that it go to Cody and that it go to Janet afterwards. Now you're going to find there might be a couple of ways you can get creative to handle something similar, but the full ownership of something, once you give it to someone, stops. Okay? And so the prohibited substitution, hand from the grave, big no-no. The Ledbetter succession, I guess, is in support of that particular topic. All right, the next sentence says, in the event the donee violates the condition, the sole remedy is the dissolution of the donation and the return of the property to the donor or his descendants. So we're going to talk about dissolution and revocation of donations. What they're talking about right here is a dissolution of the donation. But they're talking about dissolution of the donation, the one that Mom and I were involved in, where Mom donates the property to me on the condition I continue to have all the family functions at the house. And the very first Christmas that rolls around, I tell everybody, do not come to my house.
Not even put up a tree.
That's right. Don't even think about coming to my house, you bunch of freeloaders. It's not going to happen. And And then all of a sudden, I violated the charge for which the donation was stipulated. Now she's got a basis to move to dissolve the donation because I'm not honoring the condition that I took it with.
If she's still alive.
If she's still alive, that's right. Now, if it's a donation mortis causa, if it's a donation mortis causa, and I inherit this as part of a testament, the testament says, I leave my house to Ray on the condition he continue to have the family functions.
Can't do that.
No, she can do that. She can leave it with a charge. She can leave it. What she can't say is, in Ray, if you don't want to do that, then you've got to give it to Danny, or Danny, you've got to give it to Bo. She can't do that. But let's say she does give it to me with a condition, and she's dead. Now, what we're thinking is that, oh, she's dead. Nobody can do anything about it. But who could? My brothers.
The ones who were
The ones who would stand to gain from me losing that house.
Yeah.
They're the ones that can bring an action.
Thanksgiving.
Thanksgiving is the
They're
one.
knocking on the door.
Right. I'm pretending to turn off all the lights and So yeah, the idea that she may not be alive to bring the action doesn't necessarily mean that the action can't be brought. Because if the donation, even whether it's inter vivos or mortis causa, gets dissolved, if the donation gets dissolved, now this is an asset that's going to be probated through her estate and testate. All of her children will take equally in that house. So the house that I had 100% of, I'm going to be reduced to 1/3 of as a result of not following the condition upon which I received it.
Christmas party.
Yep. Onerous and remunerative donations. Donations that are made with a charge or condition imposed on the donee where the cost or value of the charge imposed equals or exceeds 2/3 of the value of the thing donated are called onerous donations. So what they're saying is that what you're really donating there is something that's going to be equal to less than 1/3 of the value of the asset. So it appears as though I'm donating you the entire asset, but the reality is there's a balance on the car that's got to be paid. Or I owe you some money that's an offset of what you're receiving it for. We're kind of getting into the area of this being a potential exchange,
Or
but
a
there's
sale.
or a sale. But there is some equity in the asset you're receiving, and that's what's causing it to fall into this onerous category. It says, similarly, donations that are made to compensate for services rendered by the donee in the past, where the value of those services equal or exceeds 2/3 of the value of the property, are called remunerative donations.
Say that word again.
Remunerative?
Remunerative. We were trying to figure that one out.
Remunerative. Anybody have a different pronunciation for it? What about you, Sanjina? No?
It's just like Washington.
Just like Washington. Where a donation is found to be either onerous or remunerative, the rules of donations found in the Civil Code do not apply. In those cases, the rules applicable to ordinary contracts apply because they are not considered to be true donations. Although the rules regarding the form of the donation acceptance are not applicable to onerous and remunerative donations, provisions governing other acts may nonetheless apply. For example, where the onerous or remunerative donation is one that transfers title to movable property, it must still be in the form of an authentic act or an act under private signature. Now, what they're talking about here...
Wait. Okay, you're going back. Go ahead.
No, go ahead. What's your question?
Well, you still, even though it's an act of donation, you would still have to do a closing. What I call a closing, a title transfer with deed and everything.
You need a notary?
Yeah, okay.
Yeah.
I mean, you need to have like a regular, you do a new deed, you do the whole.
Yeah, if it's involving a piece of immovable property.
If it's real estate.
Yeah, you have to have a deed. And what they're talking about there is they talk about how an onerous or remunerative donation can be done as an act under private signature. Before we get too far, let's make sure that we're clear as to what an act under private signature is versus an authentic act. So who can tell me what an authentic act is?
Notarized in front of a notary.
That's an act under private signature. An authentic act is going to be before a notary and two witnesses,
Two witnesses.
where the witnesses meet the criteria of being witnesses there, not the notary, not the principals to the act, that kind of a thing. And so anytime I see donation at the top of a document, I'm looking for an authentic act, because you're going to find that donations, the gratuitous donations that are not done in the form of authentic act, are null and void. You can't do a donation that way. And so what they're saying is, hey, these onerous remunerative donations, these are kind of quasi-exchanges or quasi-sales. You can kind of get away with executing these transactions similar to the way you'd execute a traditional sale with proper consideration. And that would be where it's just notarized and act under private signature. So
They try to do that a lot in states that have, like Maryland, that have extremely high transfer fees on real estate.
we run into that just a little bit here too, where people try to stipulate that the value of the property being sold is a lot less than what it is because they don't want to pay the property taxes on it once it's sold. Or they'll try to use the common law quitclaim language where they'll say for $10 and other valuable consideration, but they won't recite it to try to put the burden on the assessor to figure out what the asset is worth. Morris Bart got in trouble with that one time. Morris Bart bought a house in New Orleans, paid like $3 million for it, but insisted that they only put $10 in the deed to kind of throw the assessor off so the assessor wouldn't know exactly what he paid for the house and wouldn't automatically tax it the $3 million. That didn't fly. I mean, people saw Morris Bart paid $10 to live in this fancy neighborhood. The first thing they did was go screaming and hollering that you've got to give us the value because they want to collect their property taxes.
You can't believe the Beverly Hills real estate that gets transferred for $1.
Yes, because in some states, like in
I worked
Mississippi,
on-
everything's done for $10. In some states, sales prices are confidential. Louisiana's not one of those
California
states.
is confidential.
So we have public records, and we have to disclose the actual consideration for these sales. All right, so let's go before we kind of got our meeting kicked off. Shannon was talking about the differences between onerous and remunerative donations. And Shannon, I think that what we're talking about here is onerous and remunerative donations. You've got a below 2/3 and an over 2/3 value. And then what you're looking at in the onerous donation, it says the rules to peculiar inter vivos donation burden with an obligation imposed on any as a result of material advantage to the donor, unless at the time of the donation the cost of performing the obligation is less than 2/3. Onerous is going to be less than 2/3. Flip the page. Remunerative is going to be more than 2/3. No, unless the time of the donation the value of the service is less than 2/3 of the value being donated. I'm on 125 and 126. What's your question, Patty?
Look at 125, I think they have a typo in here.
That's gotta be a typo, because it says exactly the same thing.
It does, it says equals or exceeds, and then it says, remunerative equals and exceeds.
It sure does.
And then on the bottom is the
Typo.
correct thing.
Where exactly is the typo? We struggled with this for 15 minutes for y'all, where everybody sat down. Where exactly is the typo?
Okay, it says the
After
same
the
thing.
bold, onerous and remunerative.
Right.
Remunerative, see where it says on the second sentence? Charge imposed equals or exceeds 2/3, and then it says it the same thing for the,
Remunerative,
I
right?
think the
But it
word
says it
less.
correctly in the article. That's on 125.
Yep. Let me catch that.
It's less than 2/3.
Yeah.
It says here.
I think on page 126, the word less should be,
I think it should be, yes.
I think on page
The article is
126.
correct, right?
Well, no, if you look at the Article 1526 on page 125, then look at the Article 1527 on page 126. Does it not say the exact same thing?
Yes, it does. I
So-
think 1527 needs to be
man.
corrected.
So which way?
And then in the body of
Everybody
it, up
got
here,
a-
above it.
Yeah.
And so above it, it says exceeds,
Right.
and then remunerative is less than, and then in the articles, they're both less than. And I was trying to rationalize that answer to Shannon before we got the meeting started. What I'm going to do is this: I'll get the actual articles out of the civil code.
Good.
I'll bring them to our next meeting so that you'll have them.
Okay.
But I'm fairly confident, even though I said that what's in the statute is going to be correct, because both statutes say the same thing, they both can't be correct. So one of these is going to be wrong, but I'll bring in the actual civil code articles from the civil code for our next meeting that we'll have them. I'll tell you what I'll do, I'll scan them, I'll email them to everybody, we'll do that tomorrow, so you'll have them before the weekend.
Isn't
Okay?
there a link where we can just look them up?
Yeah.
Yeah.
It's Louisiana Legislative Search,
Yeah.
and when you go to that website, they have state laws, you click on
That's where I
state
couldn't
laws.
find title, Article 31.
Mhm.
Still can't find it.
All right, so page one. So we're going to come back to that. One of those is right, one of those is wrong. We're going to come back to that, and I'll get you that answer tomorrow morning. 126 dispositions considered null by operation of law. The following dispositions, either inter vivos or mortis causa, are null by operation of law: a donation inter vivos of the whole of one's estate. A donation that is contrary, yes, a donation that is contrary to law or morals or contains an impossible condition. Prohibitive substitutions. A donation of future property. A donation made on a condition, the fulfillment of which depends solely on the will of the donor. A donation conditioned on the donee paying future and unspecified debts or charges unless those charges are explicitly stated in the donation. These are all null by operation of law.
That was on the test.
That's on the test. I have a client who, I haven't seen him in a while. Maybe he's kind of changed things around, but for the longest time, he was my client because he owed everybody money. Everybody money. And so he was always kind of robbing Peter to pay Paul, kind of getting by. and he managed to convince his brother and his sister to give him some money, but they wanted something in return. They had an elderly mama who had some property, and she was going to be passing away, and they wanted all of his interest in the property he was going to inherit from her when she died.
They were pre-buying it.
They were pre-buying it. So they went to their attorney who was in Baton Rouge, and they got some advice from their attorney, and their attorney said, listen, what you don't want to do is you don't actually want to buy this property, because what you're doing is you're kind of putting it out there to all of this guy's creditors that he's now coming to some money.
Ding dong.
What you need to do is you need to have him donate the property he's going to inherit to you. And there's a little thing in Louisiana called the after acquired title doctrine that says that once he inherits it, it will automatically become yours via the donation you executed in advance. And so all three of them, he's in Baton Rouge, my client's in Slidell, the sister's from St. Bernard, and the brother is either from here or St. Bernard. So they come here because it's more convenient to have me draft the paperwork than it is to go to Baton Rouge and have this guy draft the paperwork. And I go into the room with them and I'm listening to what they want to do, and I tell them, what did I tell them, Patty? What did I tell them?
I'm sorry.
You are paying attention to?
I'm tired.
That's okay. Jolie, what did I tell them? What do you think I told
I
them?
don't know.
Don't know? Does
I
anybody
can't
have
do
any
this.
idea what I told them?
Yeah, I can't do this.
That's what I said. Why can't I do it?
Because a donation conditioned on the donee paying future or unspecified debts.
No, go up, go up,
One
go
more?
up, two more.
100% of
Two more, donation of future property. He doesn't own it yet because nobody died, so
That's
it's
right.
future property.
I said, listen, I don't disagree with the attorney in Baton Rouge, guys. I said, I don't disagree. The after acquired title doctrine works, and I think that if you were buying this interest from him, it would work. I said, but there's an exception to the after acquired title doctrine in that the transfer of the property's got to be valid. And because he does not yet own what he's donating to you, this is not going to be valid. I don't think this is going to work. And the brother, not my client, but his brother said, listen, Harvard, we're not in the market for a new attorney. Can you draft these papers for us or not?
No.
Wow.
You know what I should have said? I should have said, no, I can't draft the papers. I said, no, I'll be happy to draft the papers for you. But I'm going to put a big disclaimer in there that says, and typically if I don't do any title work, I'll put a disclaimer in there that says, hey, I'm not doing any title work for you. I said, in this particular case, I'm going to put a disclaimer that says, I advise you against this transaction and you're doing it anyway.
Uh-oh.
Because I don't care what you put in it, just draft the papers. So I went and drafted the papers and I put the disclaimer in it. It says, listen,
Really?
Harvard. Yeah, listen, Harvard.
Harvard,
We're not in the
yes.
market
He
for
said,
an attorney.
okay, yeah, I'll do it, but he's signing away the right to come back at me.
So the donation against all of one's property, I heard an oh no.
Yeah.
That you don't. Now this is the idea. You know when that happens? It happens when people are getting old and they're concerned that they're going to fall into the need of long-term care and they don't want to dispose of all their assets to pay for that long-term care because the state won't subsidize the cost of your long-term care unless you're broke.
$6,000 a month.
$6,000 a month. And so in the waning years of your life, when long-term care becomes an inevitability, the first thing you want to do is go out and give everything away because you'd rather have someone else have it than give it all to the state.
Rather than the nursing home.
The prohibition against all of one's property, that's not the only time that you see it, but that's the time where you see people making the argument that those transactions aren't valid. Who makes those arguments? The state makes that argument. The state comes back and says, oh, all that stuff you gave away in the last year or two, go get it all back. And then liquidate it. And then, once that money's gone, then you can come back to us for some subsidies.
But if you do give everything away, then they have to have like, in there, a time restraint before
Yeah.
it's okay to do that?
Well,
5 years?
there's a look back period. So what happens is when you apply to the state for long-term care, they ask you if you've got any assets in the last 5 years. If you check, no, I haven't had no assets in the last 5 years, the state won't typically look past the 5-year mark. So if you've given everything away 6 years ago, 7 years ago, and no one's challenged the validity of that transaction to begin with, the state's not likely to do it because they're not looking past 5 years. Doesn't mean the state can't do it. It just means the state doesn't typically look past the 5 years.
Oh,
But
I thought it was a set time. So
But you see,
evidently
the
not.
law would suggest that there should not be a set time. It's my understanding, and I'm not an expert on long-term care needs, I'm not an expert. My understanding is it's more of a policy issue, that the state sets the 5-year time frame as a policy issue. If the law would suggest that you can't give all your property away, I don't know why 5 years would be the prescriptive period on that. I would think that if you did it in contemplation of not paying long-term care, there would be at least a 10-year prescriptive period associated with it, I would think. So the idea is that and this is not the only time you see it. This is not the only time you see it, but you typically see the divesting of all your assets in those situations. But I had a client come to my office the other day. It was her and her mom, and their brother had just passed. My client's brother had just passed away. Son just passed away, and he was single. He had been married, never had any children, but he was single at the time of his death. And so the mother and the sister knew that they were going to inherit his stuff. And he had a house, nice house. He had a motorcycle, 2 cars, and money in the bank. Okay, so he had some net worth.
Yeah.
So we're sitting down, I'm getting all their information, we're going through, and I hop online to get the legal description of the house, and I notice in the days before he died that he donated the house to someone with a power of attorney. So I said, hey, who is so-and-so? And they said, I've never heard of that person, I have no idea who she is. And I said, well then who's so-and-so? This is the person who acted as his agent. She says, that's his ex-wife. What was the first name again? And I said, so-and-so. She goes, that's the ex-wife's sister. And I said, what do you bet? The checking account's closed, and the cars have been transferred, and the motorcycle's been transferred. She got a power of attorney on his deathbed and gave all of his stuff away to her sister. Buffy, I thought you might kind of find that interesting because Buffy was involved in a case where a person misused a power of attorney to give everything to herself. In this particular situation, this woman was smart to know, I can't give it to myself. But you know what? I'll do the next best thing and give it to my sister. So they came in, and the mama started crying, and I said, whoa, hang on. They can't do that.
This can be changed.
Yeah, first of all, the power of attorney's not been, the agent for the power of attorney, they've not acted in good faith in giving all this man's stuff to his ex-sister-in-law. There's no validity to this transaction. I said, secondly, it's against the law to give away everything you've got. There's a basis for going and undoing all this. It's got nothing to do with the good faith status of the principal or the agent or the recipient. It's a prohibition against giving everything you've got away. I said, so that we've got a basis for challenging donation and bringing everything back, regardless of any other variables associated with it. Because one of the other big issues was that at the point in time this document was, the power of attorney was signed, he apparently wasn't even coherent.
He wasn't.
He already-
was on his deathbed.
he was already- according to
the
the-
capacity to
Exactly. Well, according to the sister, he was in a coma on that day. There was no way in the world he could have signed a power of attorney, so that we had the ability to possibly challenge the validity of the act. We had to possibly challenge the validity of the act on the basis that there was no value to the principal for giving everything to his sister-in-law. But no matter what happened, even if he had a moment of clarity, even if he came out of his coma for just a moment, just enough to sign a piece of paper, and the notary was willing to testify to that, we still had, she used a donation to give everything he had away. Everything he had away. And on that basis, we go back and undo that donation because that is a prohibited action. You cannot donate all of your property.
So did it happen? They got it back?
I'm embarrassed to tell you that we did a conflict search, and our law firm represented his ex-wife.
Oh.
And so we had to,
Oh.
we didn't represent her in that matter,
Yeah.
but we had represented her previously, and so we had to bow. I referred her to a good friend of mine, Mr. Ernie Anderson, and I would imagine Ernie took care of it. Yep.
Is that criminal? Would there be any criminal culpability in that?
I would imagine it could potentially be criminal depending upon the outcome. Let me tell you what I anticipate would happen. I anticipate that they would send the sister who got everything a letter saying, listen lady, you're in a world of hurt. You know, your sister acted in bad faith. She did a potentially criminal act, certainly a civil violation, and you're about to get drug into all this. And if your plan is just to give your sister all this stuff when the smoke settles, the best bet is give it all back right now and walk away from it clean before you have to go paying a bunch of attorney's fees.
But
That's the nature of the letter I would have sent. What Ernie sent, I have no idea.
But that notary should be in,
Oh, I've
especially
actually-
if that person was in a coma.
I hear you. You know what that notary's going to say, and I don't even remember who the notary was, to be perfectly honest with you. But I have been in hospital rooms with people. I was in a room with someone that they brought out of a coma to execute his final documents.
Oh, no.
Yeah.
All right, and that's weird because people don't come out of those things very. It's not like waking up on Sunday morning, you know. It's exactly. It was kind of a violent thing, but he had requested I be there with these documents. So that notary, that person could have had a moment. You know. So I'm not quick to throw the notary under the bus. I don't want to throw the notary under the bus, but. If we'd have taken that case, we would have certainly explored it.
If you would have, the notary would have
We would have explored it, absolutely. All right, so this is the prohibition against donation of all property, page 126. Where there is no forced heir, the only limitation on the amount of property one can donate inter vivos is that the donor cannot donate the entirety of his estate. Generally, if a donor fails to keep enough property for his subsistence, the donation is null. Where there are forced heirs, however, the articles governing the disposable portion of one's estate must be taken into account. What's a forced heir? Well, can you be a little more specific? I mean, you're on the right track.
Any child under the age of 24 or that fits the criteria, I think you still can be a forced heir over the age of 24 if there's some type of mental incapacity.
Awesome, Sanjay. That's great. So you're 100%. You're forced heirs of your kids, but there's actually a point where your kids aren't forced, and typically it's the day they turn 24. So they're forced 23 years, 364 days. When they turn 24, they're not forced anymore. But if they have a mental or physical disability, they can be forced long past their 24th birthday. Essentially, the test is, are these children going to be a burden of the state? Are they receiving any kind of state subsistence for their disability? If the answer is yes, then they're going to probably fit the category of being a forced heir, because the state doesn't want you to deny your disabled child compensation or revenue or wealth when they're flipping the bill for everything. They want them to at least get their forced portion, and if that's gone, then that's gone. All right. Prohibitive substitution on top of page 127. It says every disposition not in trust, that is a disposition not made under the provisions of the Louisiana Trust Code, by which the donee is charged to preserve and then give a thing to a third person at the end of a certain time, or upon a certain condition, is null as a prohibited substitution. In other words, a gift of property to one person cannot be conditioned upon the property transferring from the donee to another person upon certain conditions, such as the death of the donee. All right. Can anybody think of a creative way to get around that? I have a house, and I want to give it to Sanjanita, and I want Sanjanita to give it to Cody when Sanjanita dies. Now this says I can't do that. Prohibited substitution says I cannot do that. Does anybody have a creative way where I can pull it off?
You just give it to me, just to give it to me, you're not dying or anything. You just donating it to me?
Yeah, I'm just donating it to you. I'm just donating it to you. But I want you to give it to Cody when you die. And I can't do that. That's a prohibited substitution. I can't do that. Is there any way I could accomplish that anyhow?
Give it to Cody.
No. I want it. I hear you. I want Sanjina to have it. But when she dies, I want Cody to have it.
Okay.
This is how I would do it.
You would stipulate it, right?
What's that?
You would stipulate it.
That'd be a prohibitive substitution. Can't do it. This is how I would do it.
During the course of the donation, you could maybe sell
I would give you the usufruct of it. And I would give Cody the naked ownership. That's what I would do.
And then how does Cody get it?
When she dies,
He's give him the house.
Is it usufruct?
no, I'm going to give it the usufruct of the house, naked ownership of the house.
Oh, he gets naked ownership, she gets usufruct.
When she passes away,
It goes
gets
to the
it.
naked owner.
nothing against nothing says I can't split up the ownership.
Okay.
I just can't give the house to Sanjanita and say, Sanjanita, you've got to give the house to Cody. But I can give Sanjanita the usufruct, and I give Cody the naked ownership.
And I gotta look
But
at
did
my
you
will.
said you were donating it to me?
Uh-huh.
So
I'm donating the usufruct to you.
you're donating the usufruct to me?
That was
Okay.
exactly. Now, in my initial question, I said I'm donating you the
Right.
house, but I want you to give it to Cody. That can't happen. How can I accomplish it? And the answer is I donate the usufruct to you, the naked ownership to Cody.
Two
But I'll-
separate transactions, or can it be in the same?
That, they probably need to be in the same one. I would
The same
think.
one?
Yeah.
Now, if you had, could someone challenge that? If you had I'm just thinking.
Well, listen. If that was the last asset that I owned,
Yeah,
then it would be a prohibition
All your
against the
property.
donation of all my
Yeah.
property.
okay.
But if it's a house that I own and I got 3 others, no, nobody's going to challenge it on that
But it
basis.
can't be the only one?
It
You
can't
have to
be
have
the
something
donation
else to
of
be
all my
decided.
property. It can't
Your
leave
last
me. It
asset.
can't leave me broke.
Okay.
You could just still have a car.
Well, what it says in that section is that
Does your assets?
I need enough for my own subsistence.
That's what I'm saying, it had to be
It's a van
certain
with a
amount.
kitchen.
Yeah. All right. Well, I probably do just fine in a van with a kitchen. All right.
If you had forced heirs,
Yes.
then you couldn't do that, right?
Um.
In other words, your children, you couldn't cut your children out by giving her usufructs and giving him naked ownership.
Now, am I alive? I mean, is this a donation inter vivos that we're talking about, or
No,
donation?
you're still alive.
All right.
Still alive.
Yeah.
You could still do it.
Sure.
And cut out your children.
Yeah, I'm still alive. Forced
Okay.
heirship is a mechanism of my death.
Got
Okay.
it.
Forced heirship is a
Okay.
mechanism of my death. Now look, there's a window. I don't know. I can't remember off the top of my head. There's a window where they might be able to go in and challenge that transaction if there's not enough of my estate to satisfy their forced portion. And when we get into forced heirship, you realize the forced portion is not a significant portion of the estate.
Oh, okay.
And so if there's not enough to satisfy the forced portion, and this donation to Sanjanita is something I do in the days before I die, they might be able to go back and challenge that transaction to recover their forced portion. But if their forced portion can be satisfied from the balance of my estate, no, they can't go back and challenge that.
Did they get
You
the
have-
I don't give you any ideas now. But no, they can't go back and challenge
So
that.
if you have 3 children that are not forced heirs, they're over 24, and you do that, that's just done.
That's just done.
That's just, it's just done. That's
Yeah, it's
just
got to be
done.
forced for it to be interesting. If they're not forced, they're all over 24 and there's no disability.
Right.
There is nothing in the law that says you've got to leave your grown children, your adult children over the age of 24 without disabilities. There is nothing in the law that says you've got to leave them anything.
Simple this, I had to show my children.
All right. Now, we could have also left it in trust.
I was fixing to say, you gonna bring that
I was
up?
getting ready to
Another
say
way.
the trust.
Yeah.
Is that
I
later
think what I
on
did
in
when,
here?
when I drew
We
it,
don't-
Oh, dear
my
God,
brother
yeah.
was dying, and he had cancer at the time. But I think I had to draw it up to where he would inherit everything. But I think the lawyer put it where if he would pass before I would, then it goes into a trust for my nieces and nephews.
Okay.
Because I never had any kids.
Okay.
So, I think that's how he did it. That's why I'm like sitting here listening.
No, look, that works. That works. So your brother was the primary beneficiary of the trust. Your nieces and nephews are the secondary beneficiaries of the trust. Trusts are almost kind of set up like insurance policies in that there is a beneficiary to the trust. There's someone who receives either the assets of the trust or the income of the trust. So one of the ways to do it would have been to also create a trust. I could have
Notaries
created
can't do trust.
Who?
Can we do trust, notaries?
Sure.
Louisiana notaries can.
Yep. So I could have created the Brinson Family Trust, and I could have named Sanjanita the primary beneficiary of that trust. And upon her passing, I could have said Cody is the secondary
There you go.
beneficiary.
So that's another
So
way to do it.
there's
Go on
other
and
ways
on
to
and
do
on.
it. Other ways to do it. The trust is a good way. The naked ownership, they both work. They both would have worked just fine. Right of return, page 127. The donor may reserve the right of return of the thing given in the event he survives either the donee alone or the donee and his descendants. The effect of such reservation is that it cancels all alienations of the property donated that may have been made by the donee or his descendants and causes the property to return to the donor free and clear of encumbrances. Boy, I bet the banks are going to be upset about that when that happens. What do you think?
The bank that you owed money to?
Example.
All right, so the example is that I make a donation to you, Sanjanita, and I reserve a right of return in that transaction. And then you go to the bank and you borrow a bunch of money against that house. And then you die. This statute says I get the house back free of that encumbrance, which means that the bank can't get the house to get paid back. I get the house free of it. Don't you think the bank's going to be upset about that?
Why would the bank?
Well, why would the bank not know about
Right,
that
that's
stipulation?
Why?
That's
It's not recorded?
It's got to be recorded. That's my point. That's
Okay.
exactly my
That's what I was
point.
gonna
The bank's
say.
never going to make that transaction because the right of return is going to be in by the document
Okay.
itself. They're going to see it.
They're
It's
gonna
going to be a
review it
triggering
after
mechanism for them
donation.
not to do the transaction to begin with. They're going to say, "I'd love to make this loan to you, but there's a right of return in it." And that right of return could potentially cancel out our mortgage on this property. For that reason, I cannot make you this loan.
And then the bank sells your mortgage cancellation insurance for $50 a month.
But then not they can't make me the loan.
They will, if you
Yeah.
buy the insurance.
No, I can't imagine. You see, that you can't sell an insurance product like that knowing that there's going to be a claim on that policy. I
There's a
mean,
potential claim in all policies. We sold it, it's called Buyer's Protection Plan, and you can't believe how many people bought it because of that.
okay, I'm not familiar with
It's
the
a national
product.
bank, I think they've probably done away with the product now because there was so much money on it, but it was called Buyer's Protection Plan. And it canceled your mortgage if you died.
Well, no, that's credit life insurance.
life,
It's credit
yeah.
life insurance. I know what you're talking about, and they still have credit life insurance, and
But that's different.
that's different. You know, this particular situation it's a situation where now what Lorraine's saying is that if you had credit life insurance, I see what you're saying.
They still would make them, they
The
could
bank,
still make
okay,
a
so
loan.
what Lorraine is saying is this: I give Sanjanita a piece of property and I reserve a right of return in it, and she goes to the bank to borrow money, and the bank says, "Listen, Sanjanita, I'll make you this loan, but you got to buy life insurance, and if you die, we get paid because if you die, we can't recover the property because it's going back to
Right.
Brinson." So I can see how you might create a product that would make the bank comfortable in making the loan, but just for the purposes of saying banks probably aren't going to make that loan. They're just not going to want to be involved in the situation.
For all
The home
intents
mortgage
and
business was
purposes of
crazy.
the test, okay, how
Yeah.
would they give us, because it's really a given that they're not gonna do it, so how would they sort of try to trick us up on a question on right of return?
Well, I think that they would.
Just like you gave your example with the mortgage.
Right, I think that they would probably say, okay, Brinson gives Sanjanita a piece of property, and there's a right of return that's in it, more facts, Sanjanita passes away. And then probably a series of scenarios, hoping you still remember that the mortgage that's on the property gets stripped when it comes back to me. That's what I think they're going to know. Do you know that a right of return causes the property to come back to the donor in the condition it was in when the donor gave it, and all the donee's encumbrances that are created subsequent to the donation have got to be stripped from the property as part of that. And if the right of return is not in the document, then I don't think the right of return has any value. That goes back to the public records concept. If it's not in the public records, it can't have any effect on third parties. So I don't think that I could go to the bank after you were to pass in our example and say, oh, by the way, Sanjanita and I had a right of return, here it is in writing. Oh, it wasn't recorded, no one knew about it, but we clearly had a right of return, I want the property back. I think the bank would have a great argument for saying, sorry, don't work that way.
Yeah.
You've got to be in the public record. So maybe there's an example in the test where the right of return is not recorded with the act. See if you realize that the fact it's not recorded in some way, shape, or form invalidates the way that the right of return is supposed to work.
So the bank orders the title search and the abstracting is done by
An abstractor.
the abstractor. It's their responsibility to catch that.
Actually, that's not the case.
That's not the case.
It's the abstractor's responsibility to capture the document that is the donation.
And then
It's the
exhibit
title
that.
examiner's job to catch the right of return in the donation
Oh,
itself.
so there's a different person, a different.
Yeah, an
different
abstractor
role.
is a person who solely compiles all the documents,
Okay.
but is generally not an attorney and is not allowed to render a legal opinion about something.
But they can catch the clause
They,
and
they,
turn it over.
they turn the document over to an attorney reviews it, and unfortunately in Louisiana, only attorneys can review titles. And so an attorney reviews it and then makes an opinion based upon that title, and it's the attorney's job to catch it. Now the best abstractors are the ones that point that stuff out to you. The best abstractors are the one that say, hey Ray, take a look at the right of return.
Did you see this?
And did you see this?
They have a little
Take a look at
post-it
this.
note on
And then I make a
there.
note, make sure you send more files to him. All right. Form of donation on page 128. It says, form especially with regard to donations includes formalities of ritual. When authentic act is required, it is not sufficient to merely collect the signatures of the act. The parties must sign in the presence of the notary and the witnesses, who must also sign. The notary and the witnesses must observe the parties sign the act, and the notary and the witnesses must not sign until all parties have signed. Should the notary or a witness sign an instrument in advance of a party's execution of the same instrument, the act will not be an authentic act with respect to the party's signature. Strict adherence requirements of form. I told this particular story about a client of mine that unfortunately just got kind of stuck in a situation where he went to Office Depot and pulled up a donation form, and then went to a notary to get the document notarized. And he was the good brother who took care of his mama for the last years of her life, and before she passed away, she wanted him to have her house. So they go to a notary, they execute the donation, it gets recorded. Mom stays in the house, everything is good, enough time has passed. The sister is over the age of 24, there's no forced heirship issues. The mama finally passes away, and here comes the sister. And the sister says, I want my half of the house. And the brother says, no, it's my house, Mom gave it to me before she died. And she goes, no, I've seen it, the donation's not valid. And what had happened is that Office Depot had a donation form in their little form section that call for what they have, they call for a subscribing witness, where the donation is signed by the donor, signed by the donee, signed by two witnesses. Then a witness goes before a notary, and the notary signs saying that they verified the witness's signature. And
So there's a witness to the notarization of it.
there's a witness to the act,
And then
and then the
witness to
notary is
notarization.
testifying that the witness came forward and testified that they were a witness to the act.
Yeah.
And so he rolls into our office and says, this is what my sister's saying, is it true, is it true? And I looked at the document and I said, it's true. I said, why did a Louisiana notary execute this document? He says, I just brought it to the notary and the notary notarized it. I said, you didn't sign this in front of the two witnesses and then the witness will go before the notary? He says, no, we were all in the same room, we're all at the same time. So what happened was, it was executed like it was supposed to be an authentic act. The witnesses, the parties, the notary, they were all there. But they filled it out as the form had been drafted, creating the appearance that it wasn't an authentic act. And now enough time has passed, no one was comfortable testifying as to whether or not they were in the room or not. You know, the person who was receiving the property, the donee, the brother who was my client, he remembered it like it was yesterday. When we talked to the notary and the two witnesses, they kind of waffled. You know, people come in here all the time, I don't know that I really remember it. And because we couldn't establish the fact it was done in the form of an authentic act, and because strict adherence to requirement of form, it's in big, bold letters. Because strict adherence to requirement of form is an absolute must on transactions like this, he eventually lost half the house to his evil sister. So here's a situation where, all intents and purposes, this transaction was done right. Had a notary, we had two witnesses, we had the donor, we had the donee, we had capacity, everything was being done right. But the form of the document was not consistent with the law, and no one was smart enough to catch it or bring it to their attention that, although I appreciate the fact you bring me this form from Office Depot, this form's not going to work. Why don't you let me draft a real donation for you that won't be challenged, or you won't have to give half the house to your sister. Now, what if the sister never comes forward?
No problem.
No problem, right? Because it's only an issue as to form
When it's challenged.
if it's challenged. Now look, he might have had a hard time borrowing money against that house because the title company that would have done that closing would have seen that document, would have had some questions whether the mom really transferred her interest or not. He may have even had a hard time selling that house, but unless the sister comes forward and says, I challenge Leah's donation, chances are he continues to live in that house without any interruption. I mean, it's not like Clico's going to come turn the power off because the donation's not done right, you know? So sometimes things aren't done properly, and if they're not challenged, there's never any apparent consequence to it.
If that notary had kept a log of that transaction with all of who was in the room, would that have maybe
I don't think so.
bolstered your
I don't think so, because even if the notary and the witnesses would have come forward and said, hey, we were all there when it was acted, the appearance of the transaction would have been too much to overcome, in my legal opinion, been too much to overcome. We have a legal concept in Louisiana called the Four Corners Doctrine, which means that we really can't take extrinsic evidence and make a contract work based upon extrinsic evidence, which is what we were trying to do by bringing in the notary and the witnesses to testify. If we're going to look at the face value of this document, the face value of the document would suggest it was not done in the form of an authentic act.
When do you think that's going to become part of transactions?
In Louisiana, I don't think it's going to become part anytime soon.
Videotape every single one you do and keep a record of it? You don't think that'd be admissible in evidence?
I think it might help in certain situations, but it's not going to make anything valid. I had some clients come into my office recently who videotaped their dying brother in the hospital, and he did a video will. And it's clear as day, he's coherent, he's got capacity, and he says, I leave to my two sisters, my car, my checking account, my this, that, and the other. He had a son. He wasn't estranged from his son, but his son lived in Australia, and he hadn't been home in 15 years, and so they didn't really have a lot of contact except by email. He went to the sisters' houses for Christmas, and he went to the sisters' houses for Thanksgiving. He felt a real kinship with them, and he left them a bunch of stuff. And so they came in, and they put the phone on the table, and they hit the play, and I sat there, and I watched it, and I said, okay, what you want to do with this? She goes, well, I want you to probate the succession, and I want the car, and I want this, and I want that. And I said, we don't do video wills in Louisiana. This is invalid.
Unless it's written.
It's got to be written. It's got to be written in a particular form. It's got to meet certain criteria. I said, this doesn't work. I'm sorry. The son came in about 2 days later, and he met with me on the recommendation of the sister, and he was going to inherit everything because the dad died without a will. That video will was the only thing he had. And so I told him, I said, listen, I'm sure your aunts have told you that it was your dad's desire to give them certain things, and there's a video will, but you know it's not valid in Louisiana. Everything's going to you. What you do with it's entirely up to you. And he did the right thing. He gave the cars to the sisters. He gave the money to the sisters, his aunts. He gave it to them, but he had no obligation to, none whatsoever.
Wow.
So that video will could have been introduced all we want, and it would have had no impact on the transaction at all. Now, I'm not saying that maybe if we're in a closing and someone disputes something that's said, that you couldn't introduce videotape testimony to contradict it. Yeah. But it's not going to make a transaction valid or invalid, not underneath our current laws. Authentic Act required on page 129, no matter what the property, except when otherwise permitted by law, a donation must be made by an authentic act that identifies the donor and the donee and describes the thing donated. Here are the exceptions to that rule. The exceptions to the requirement that a donation be made by authentic act are the manual gift, the donation of certain incorporeal movables, evidenced by a certificate, document, or other writing which is transferable by endorsement or delivery, and onerous or remunerative donations. All right, so everybody understands and appreciate what the manual gift is, right? Manual gift is I physically give it to you, and delivery and the intent is enough. When they're talking about things that are evidenced by a certificate, they're kind of talking about like automobiles, right? Because I can physically give you my car. Is that going to work? No. I mean, those things are titled, and you got to go through a process to get them titled. There may be elements of a gift that are met in physical delivery, but there's no perfection of ownership until the title's transferred. Top of page 130, other incorporeal movable property, promissory notes, and other negotiable instruments. Where an incorporeal movable is evidenced by a certificate, document, instrument, other writing, and is transferable by endorsement or delivery, the donation may be either in authentic form or in compliance with the requirements applicable to the transfer of the particular kind of incorporeal movable found in Louisiana commercial laws. Onerous and remunerative donations on the bottom of page 130. It says, as mentioned above, when the value of donation equals or exceeds 2/3 the value of services rendered or obligation imposed, a donation is not subject to the general rules of form applicable to donations inter vivos. They are governed solely by the rules of ordinary contracts. This means that an onerous or remunerative donation need not be in authentic form as long as it complies with any other requirements of law. For example, an onerous donation of movable property must still nonetheless be in writing. What they're saying is it's got to be in writing because all transfers of movable property have got to be in writing. What they're trying to say is that if we get into the onerous or remunerative category, maybe we can bypass the authentic act requirement because it's not a gratuitous donation and it can actually be a satisfactory transfer in some other way, which would be an act under private signature, something that's notarized only. But as an abundance of caution, in your notarial practice, if the document says donation, I don't care if it's onerous or remunerative, you probably want to have two witnesses just to avoid the document being scrutinized. Nothing says having two witnesses invalidates a document. If anything, in Louisiana, we over-witness. I can't tell you how many documents come into my office with witness lines on them that have been prepared by someone else or have been taken out of a forms book or downloaded off the internet. And there is no reason in the world to have two witnesses on them. But we're just so accustomed to putting two witnesses on everything in Louisiana that it's there, you know. So over-witnessing is not going to invalidate your document.
Okay.
Top page 131, confirmation when a donation is improperly confected. The donor may confirm the donation if the confirmation is by authentic act. Acceptance is important, guys. In the middle of page 131, if a donation inter vivos is not accepted by the donee, it's without effect. And we used to have a method, I don't think we do it anymore, we used to have a method of what they call tacit acceptance, which is I could donate something to you, and by your actions we could determine whether or not you accepted it. Tacit acceptance doesn't appear to be a part of this anymore. It says acceptance of a donation inter vivos must be expressed in writing. The 2008 revision to the Civil Code articles pertaining to donations dispense with the requirements of the acceptance be in authentic form. Under the Civil Code revisions, acceptance is required simply to be in writing. Generally, the exception to the rule that the acceptance of a donation must be in writing, including those donations subject to alternate methods of donation, such as manual gifts, or that not subject to the restricted requirements of form discussed, such as onerous and remunerative donations. See also, I'll flip the page. All right, let's go down to page 132, time for acceptance and who can accept. This is the point I was trying to make, which is that we have to have acceptance. Now, kind of going back to this point that they were making before we kind of move on, what they're saying is that a donation, a gratuitous donation, has got to be in what form?
Right.
In what manner? What type of an act? Authentic act. Does the acceptance have to be an authentic act? No. So the acceptance can be rather informal. Remember you brought that one in the office the other day? It was that file where the mama had donated everything donated the house to the son, and then the son accepted it, but it wasn't notarized. It was witnessed and notarized. And you said, doesn't this need to be notarized? Because no, that's an acceptance of it.
That's right.
The formality of the acceptance, loosey-goosey. But the formality of the donation, very strict. Got to adhere to it. And so this document was drafted. It wasn't ours, but it's in our title. And this document was drafted. Mom donates